G'day everyone. This is the third and final video in week 9 of our admin law course. This week we've been looking at freedom of information, the question of how and when people can get their hands on government information. We've learned that the FOI Act and its Queensland equivalent represented a revolution in administrative law because they flipped the presumption about the secrecy of information. Instead of presuming that government information was secret, as a result of this legislation, we presume that government information is public. It's public information unless an exemption applies. In this video, we're going to look at those exemptions. Now, it's inevitable that when people think about exemptions, they straight away think about how those exemptions might be abused, how they might become havens for government secrecy. And that is something to keep an eye on. But in reality, many of these exemptions really are based on justice. You don't want any old person to get access to your health records. We don't want DV perpetrators getting access to police files containing their victim's current address. Everything is about balancing the public interest in the freedom of information against the legitimate interest, public or private, the legitimate interest in keeping that information under wraps. So there are a range of exemptions to freedom of information. The first one, and one of the more problematic ones, is national security. Section 33 of the FOI Act exempts documents which would reasonably be expected to cause damage to the security of the Commonwealth, the defence of the Commonwealth, or the international relations of the Commonwealth. Now, on the one hand, this makes sense. We don't want adversaries in other countries getting access to our defence secrets. I don't think there'd be too many arguments there. The problem occurs when the concept of national security is overlaid with the concept of the government's security. If something awful happens in defence, the government shouldn't be able to suppress it just because it involves defence in order to prevent the government from being embarrassed. It has to be the sort of thing that would cause damage to Australia and not just to the Prime Minister or his or her party running Australia. The second exemption is cabinet documents. Section 34 of the FOI Act makes cabinet documents exempt from FOI. Now, without turning this video into a political science lecture, the cabinet is a weekly meeting of the Prime Minister and all the more senior ministers. Cabinet is governed by a Westminster doctrine called collective responsibility, which means they can argue like cats and dogs behind closed doors. But once the collective decision is made, they all go out in public and support it. To enable this, the records of Cabinet are locked away for, depending on where you are, either 20 or 30 years, and then they're released, usually on the 1st of January. Obviously, it would defeat the purpose of Cabinet confidentiality if you could just FOI cabinet documents. Of course, theoretically, this means the government could just exempt any document by making it a cabinet document. But so far as we can tell, this really doesn't happen. Cabinet documents are all going to be revealed eventually, after all. The third exemption, found in Section 37 of the FOI Act, is law enforcement. This one really does make sense. I mean, imagine if a criminal who knew they were a suspect in an investigation could make an FOI request for the detective's notebook, or if they could find out the identity of the person who dobbed them in. I think most people would agree this exemption is just common sense. The fourth exemption, found in Section 38, is secrecy. This overlaps a lot with the national security exemption, but they are different. Access to a document can be denied on national security grounds just because the decision maker forms the view that national security is in peril. There's no need for legislation. However, some pieces of legislation specifically make things secret. They specifically impose a requirement of secrecy. In that case, the FOI Act loses out and the materials remain secret. But at least that legislation is telling us what's being kept secret. The fifth exception, found in Section 42, relates to legal professional privilege. Like any other person or organisation, the Commonwealth sometimes sues and sometimes gets sued, and the Commonwealth engages lawyers to act on its behalf. and the Commonwealth has confidential discussions with those lawyers. It stands to reason that those lawyers owe the duty of legal professional privilege to the Commonwealth, and the Commonwealth should be able to keep that legal advice to itself. It would be quite unusual, for instance, if a party was involved in litigation against the Commonwealth, and during that litigation, they were able to make an FOI claim to see what the Commonwealth's legal advice was. Wouldn't work. Strangely, though, in an important international law case, Australia fell afoul of this rule by having federal agents execute a search warrant on a law firm in Canberra who were advising the government of Timor-Leste, East Timor. The East Timorese quite rightly took the government to court over that one. The sixth exception is found in two places, Section 45 and 47. Section 45 specifically relates to confidential information where equity creates a duty of confidentiality. Section 47 focuses on commercial and trade secrets. The combination of these provisions means that the Commonwealth is entitled to protect the commercial confidence of any company that it's doing business with. Again, this makes an awful lot of sense. Imagine if there was a tender process and every company involved in the tender process could use FOI to get access to the tenders put in by all their competitors. No commercial agency would ever provide services to the government under those circumstances. Next, we have parliamentary privilege and court privilege. These exceptions are found in sections 45(a) and 46. When a person is speaking in Parliament, and that includes giving evidence before a parliamentary committee, or when a person is giving evidence in court, they cannot be sued or otherwise attacked legally for what they say. The idea is to preserve freedom of speech in our Parliament and our courts. Most of the time, the Parliament and the courts meet in public, and so things that are said in Parliament or in court are typically on the public record anyway. However, the courts and the Parliament are entitled to conduct some proceedings in camera or in secret, if the circumstances make it necessary. For instance, virtually all domestic violence proceedings are held in a closed court. In some proceedings, witnesses or parties are given anonymity, and their names are recorded either by using a pseudonym or a random set of letters. We've seen plenty of those in the immigration cases that we've come across in administrative law. If the Parliament or the court decides to conduct proceedings in private, then the institution's privileges extend to that privacy. And this makes sense. We don't want people being able to FOI the details of proceedings or the true identities of participants when the court or the Parliament has already decided that secrecy is in the public interest. Okay, we've got just 3 to go. Next, Section 47(a) specifically relates to the electoral roll. Under Australian law, every citizen over the age of 18 is required to enrol to vote, and the electoral roll contains their name, their date of birth, and their address. There are some good reasons to keep these things secret, particularly, for instance, in circumstances where someone might have changed their address as a result of becoming a victim of domestic violence. However, you can access your own details on the electoral roll. The next one's a really big one. This relates to privacy. We've already run into the idea that privacy law is its own entirely separate area of law. I don't have a hope of being able to really give you any guidance about the Privacy Act in this video. However, in the most general terms, the Privacy Act establishes a set of privacy principles which bind government agencies and many private enterprises too. The Act sets out rules for how an agency can obtain information from you, how they must store that information, how they can use the information, whether they can share the information, and how they must dispose of the information. The underlying objective is to ensure that people's private information is within their control, that it can only be collected with their consent, that it will be stored securely, that it will only be used in the ways described at the time the materials were obtained, that you can have access to your own information, and that it will be properly disposed of. Now, obviously, it makes sense that if the Privacy Act tells an agency to keep certain personal information private, the FOI Act takes a step back. You can't use FOI to obtain information which is protected under the Privacy Act. Thank goodness. The last exception is very contentious. Documents can be excluded from FOI if there is a greater public interest in keeping those documents confidential. The agency has to balance the public interest in releasing the document and the public interest in not releasing the document. This is really problematic because in the worst case, this could basically function like a get-out-of-jail-free card for the department. They've tried to put some boundaries around public interest exemptions. So sections 43(b) through to 43(j) talk about some of the considerations that might legitimately give rise to the exemption. But even those are pretty broad. For instance, under the economic public interest exemption, information might not be released if release would influence the decisions or actions of a person. Now that's pretty darn broad. All we can really do is hope that the journalists and the opposition are really holding a blowtorch to the government to ensure that these exemptions are used properly. So, what have we learned this week? Well, first, at a basic level, we've learned that administrative law relies to a great extent on the ability of normal people to obtain access to information held by the government. If the government is entitled to keep its information secret, much of the rest of admin law falls apart. It results in corrupt governments which are immune from outside scrutiny. And so we have the Freedom of Information Act and its state counterparts. We have information provisions in specific pieces of legislation, and we have the ability under the FOI Act to obtain a statement of reasons for a decision. This freedom of information, however, is subject to a range of exceptions, some of which are sheer common sense and some of which are more contentious. Those arise from the Freedom of Information Act itself, from the Privacy Act, and from other legislation which touches on secrecy. The exceptions are acceptable and even necessary when they protect the interests of the public or when they protect individual privacy. However, there is always the danger of them being twisted so that they're used not for the benefit of the public, but in order to avoid public scrutiny. One way to avoid the government abuse of power would be to have certain people who are public servants and who therefore have access to all the government's information, but whose role exists outside the normal public service, so they can look in and scrutinise. Our system of government has developed such an office. They're called the Ombudsman, and we'll look at them next week. See you there.